Do these questions ever wake you up in the middle of the night? How am I going to pay for the high cost of long-term care? What would happen to my minor children if something happened to me? If I was unable to make decisions for myself, do my loved ones know what my wishes are regarding health care? Should I have a last will and testament or a living trust? You're listening to Bulletproof Estate Planning with Estate Plan Stan, where we address these questions and many more. Estate planning is not just for wealthy people. I've made it my mission to tell everyone who will listen that estate planning is for everyone. Don't wait until it's too late. Your family will thank you. Hey, I want to tell you a little bit about something. I've got an event coming up. I've got another free educational seminar that I'm going to do. That's going to be August the 25th. And we're going to do that at 2 o'clock in the afternoon. That's going to be on the Pulaski Square at the Star Theater. You can just call my office at 931-363-7222 and ask to be on that RSVP list or ask more about it. We'll get you on there. Hey, I want to start out with something, and that is that for the last couple of weeks, I've been talking about one of the greatest tools, in my opinion, one of the greatest tools since sliced bread when it comes to estate planning, especially if you're worried about long-term care. And I've been talking about what is called the, income-only asset protection trust. And I was going in last week. I did a deep dive into that and was talking about what all you can do with it, what kind of control you can have over the principles of the assets you put in there, getting into the nuts and bolts of it. And wanted to finish that up today. But before I do, I want to go over something that came up that I thought was exciting, but then I get excited about this kind of law. And that is, because I do estate planning, I keep up with, court decisions throughout the country. Why throughout the country? Because there's not that many. I mean, this area of the law doesn't change a whole lot. I mean, it does change from time to time, or more likely it affirms things or disaffirms things. In other words, you read a case, case law where somebody did something, they did it wrong, and the courts will strike it down and say, no, for the income-only trust, let's say, what we want is creditor protection, okay? And the creditor that we want to have protection from is the long-term care industry, the nursing home. So, if somebody does it wrong, I'll read the case law and find out what they did wrong, and we'll know not to do that. And usually we already know that, but it's always good to affirm. But I want to talk about a case that just came out June 29th. That's 3 weeks ago, barely, from the Supreme Court of the state of Montana. Now you might say, okay, Stan, this is Tennessee, not Montana. I get that. Okay. I know I'm in Tennessee, but the reason it's important, like I say, not many, we don't have many decisions like it come out of Tennessee. They usually get resolved at the administrative level or the lower chancery court levels. We don't see, as a matter of fact, there's not been a case out of our Supreme Court that we can rely on, but we can rely on other states because other states, look at each other. The reason the state of Montana decision is important is because it had to do with the subject matter. The only thing this court was ruling on was, and get this, was the irrevocable income-only asset protection trust, which is what I've been talking about. Now, when states make decisions like this, they go and look at other states. In this Montana case, they said this question about the income-only asset protection trust was a question of first impression. That's what states do when they get something they've never seen before and they want to answer it. They don't have any precedent to go back on. So, what they do is they reach out and they look at a bunch of other states that have done stuff and kind of do what they do. Now, so Montana came out on June 29th. A case was called the Estate of Marilyn Scheidecker versus Montana Medicaid, or the Montana Department of Public Health and Human Services. And it was all about the irrevocable income-only trust, which I have been talking about. Now, let me tell you why I think this is important. People come to me all the time. They hear my radio show or they come to my seminars and they say, I want to know how to keep the nursing home from getting all my stuff and getting all my property that I spent my entire life working for. I don't want to lose it to the long-term care because, the mean average cost here in Tennessee is like $8,400 a month. So, no estate can survive that for any length of time. So anyway, the reason this, people, when they come in and say, tell me what I can do, and I tell them about the income-only trust, a lot of times they'll leave my office and think, this is too good to be true. It's too good to be true. Well, I don't know about too good to be true. I mean, there probably is no such thing as too good to be true, but this is close because this works. And I'm going to tell you about this Montana case here in just a second. So decision from the Supreme Court of the state of Montana, which is the estate of Maryland Scheidecker versus Montana Medicaid. Anyway, get this, I'm gonna call her Maryland. Maryland had a house. It was a pretty expensive house, like $600,000 home. She put it into an an income only asset protection trust. Just kind of stuff we're talking about. She also had some money she put in there, like a Edward Jones account, investment account. And what she did was she stayed out of the nursing home for about 5 years. And somewhere around her sixth or seventh year of having this in the trust, she had to go into the nursing home. When she got to the nursing home, of course, she certainly filled out a 10-care application, applied for benefits. What happened was they denied her benefits and said, hey, these assets that you have in this trust, this Edward Jones account and this expensive house, these are these are countable assets. And everybody's heard, in order to qualify for 10-care, you've got to have like less than $2,000 worth of countable assets. Well, everybody hones in on the word $2,000. That's not the operative word you got to worry about. The operative word you got to focus on in that sentence is the word countable. That's a type of asset. Everybody's got $2,000. You don't spend everything until you have $2,000 left to your name. That's not what they're talking about. They're talking about countable assets. So they were telling her that this stuff was countable assets. And so she, they denied her benefits. So she appeals it. She appealed it to two lower levels, their district court and then their appellate court. Then they finally got to their state Supreme Court, which is the highest court in the state of Montana. And lo and behold, state of Montana, long story short, they reversed all the lower courts and said, look, this is a valid way for people to plan. The irrevocable income only asset protection trust is a very valid and viable planning tool for people. These are not countable assets. We reverse and let her qualify for Montana Medicaid. So it was a big decision because, the reason Montana, I reviewed the Montana cases, their eligibility criteria are very similar to Tennessee. And so they're the same as us. It's just another state that chimed in on saying, hey, the income only asset protection trust is a grand tool. So, if you don't have one, you ought to think about it because, here we have another Supreme Court saying they work very well. So I said earlier, there's not a lot of cases on this stuff. But the reason they're reaching the courts now, at least my opinion, why they're reaching the courts now, is all the baby boomers, people like me, all the baby boomers are either coming up on long-term care or they got parents that need care like that. And so, and there's a lot of us. And so there's more and more of this going on. More and more people doing this income-only trust, which I always call the income-only trust as the ultimate secret for how not to go broke in the nursing home. So before I shift gears here and start talking about the last will and testament, if you've heard me talk about the income-only asset protection trust for pre-planning, now this is pre-planning, meaning you're not already in the nursing home. Crisis planning is when you are already in the nursing home or your loved one is. That's something else. We've got a lot of tools for that. But when you're pre-planning and you're not already in the nursing home, one of the grandest tools that we have in the state of Tennessee is the income-only asset protection trust. So if you don't have one, boy, you ought to think about it because I wanted to go over what that meant for Marilyn Scheidecker, the winner of this case. She put a $600,000 house in there and a couple $100,000 Edward Jones account. The court said, yes, those are not countable assets. You qualify. So she qualified for 10-care. 10-care pays her bill, and she still has her $600,000 house in that Edward Jones account. Now, she can do two things with that. One, she can enhance her quality of life at the nursing home. She can use that money to buy a private room, buy a private sitter. You name it. Anything that 10-care doesn't pay for, she has money now to add to it and have a pretty grand quality of life, in skilled care. Then what she also has, whenever she passes away, she's got some assets to pass to the next generation or an inheritance to leave her children. The case was silent about her family, but I'm sure she had some. And that would be, a great advantage to her. Rather than if she had done nothing at all, she would have spent all those assets and had nothing, qualified for 10-care, and then that's all you get. So you don't want to be in a situation where you're relying on a system of healthcare for everything that doesn't provide everything like 10-care. So anyway, that was the case. I was excited to read it. I keep up with that stuff. That's what I do. Want to make sure the courts are on board. So, if you ever have any of these tested in Tennessee, if it's one of mine, I feel pretty confident that we'll come out smelling like a rose because that's how we do it. All right. I wanted to get into something else because I think I talked about this on one of my very first shows, but I got a couple calls this week, people asking things like, I thought all I needed was a will, a last will and testament. I didn't know there was anything out there. What's with the trust thing? And somebody actually told me, they said, hey, I don't want my kids to have to go through, I want a will so they don't have to go through probate, which is, which is complete axiomatic at that point, because you have to go through probate if you have a will. So I thought I would review this a little bit, the last will and testament, and talk about that. So let's do it. Let's talk about a will. I mean, last will and testament. Some of you may have one. Many of you will not have one. Statistically, only 12% of you will have a will. The other 88% will not. I mean, so what is a last will and testament? Well, a will is what I call a non-operative document. Non-operative document means it has no legal effect whatsoever. You could hold it in your hand. You could tear it up. You could burn it. You could write a new one. You could throw it away. I mean, it has no legal authority, no legal significance whatsoever until the moment of death. Then at that moment of death, it springs to life and becomes a valid legal document. Now, when it does spring to life, so at the moment of death, when it does spring to life, it has one purpose and one purpose only, and that is to convey property. Now, conveying property is simply changing of the ownership, right? So, but how can a will convey property when the deceased is not here to convey it? All right. Let's take a deed, for instance, like a piece of land. You own your house, like the fellow that called before. He's got a farm. I got some acreage here in Giles County. You got this deed, and if you look at it, if it's deeded to Stan Pierchoski, which is me, then I own this property, in my own name. If something happens to me, if I get pass away, well, we have a deed that's still titled in the name of the deceased, right? So how does a deed show a change of ownership from the deceased to an heir, or to your kids, or wherever it's going? Well, it can't. It can't do it. So in order for so you have a defective title when the land is owned in the name of a deceased. So in order for the chain of title to remain intact, what happens is you have to go to probate court. You have to open up a probate case, and then the probate court creates this legal fiction. And this legal fiction is called the estate of Stan Pierchoski. And it appoints somebody named the executor in my will, where I would have said who I wanted to be the executor. And that person stands in my shoes and he conveys the property just in accordance with the will. So if you have a will, by legal definition, you must go through probate. So for the person that called me, I told them, but if you're thinking to yourself, well, I want a will and I want to make sure that my kids don't have to go through probate. Can't do it. I mean, by legal definition, it has to go through probate. Now, why is that? The reason is because, and here's a definition I want you to remember. Tuck this back in your head, and that is anybody that passes away with property titled in their name must go through probate for the very reason I just mentioned. So, if your farm says Stan Pierchoski, or it's deeded right to your name, or you and your wife, you own it in your individual capacity. And if you own it in your individual capacity, the only way it can be transferred to heirs, or wherever you left it, even if you left it to charity, the only way it can get there or redeeded or conveyed to them is through the probate process. Don't believe me? Well, just Google the definition of the word probate, and it'll say something like the proving of a will. I mean, it's the very definition of it. It's actually a Latin term, de civil vel sanon, but it means, is there not a will? It's the proving of a will. So, that's a good definition to memorize. Anything you pass away with titled in your individual name must go through probate. So, I hate to be the bearer of bad news, but if you have a will, then you're headed for probate. Okay. So now I often tell people that really there's only three possibilities for an estate to exist in this world. You either got a will-based plan, or you got no will at all, or you got a trust-based plan. Okay. The first two possibilities are you either have a will-based plan or you have no will at all. And just like I said, if you have a will, then you're headed for probate, right? Now, if you're a couple, husband and wife, really, we have what's called a first death and a second death, right? Well, there's really, there's very little time that we have to probate the first death, okay? If you're husband and wife, I hate to be the bearer of bad news, but one of you will be the surviving spouse and one of you will not. But anyway, there's rarely a need to probate the first death, because if you've been married for any length of time, just about everything is jointly owned, and it all passes usually by survivorship. So Anyway, um, but at the second death, probate is an absolute surety if you have a will or you have reciprocal wills to each other. So anyway, um, now what if you pass away without a will? Remember, I told you that 12% of you have a will, statistically anyway. The other 88 do not. What if you pass away and you don't have a will? Well, you're also headed for probate. All right, now you might say, gee, Stan, how can that be? How can someone who goes to all the time, energy, and effort and expense to hire an attorney, make a will, and someone who does nothing, doesn't even make one, they just got nothing, go through the same route as somebody who has a will? Well, the answer to that is that if you pass away without a will, well, the state of Tennessee writes one for you. God bless them. Um, anyway, it gets worse. It's already written. They've already decided who your heirs are, what percentages they get. I mean, it's called the laws of intestate succession. So when you die without a will, it's just like dying with a will. The only difference is if you have a will, you got some say in where your property is going to go. If you don't have a will, the state determines where it's going to go. So with a will, the laws of testate succession; without a will, the laws of intestate succession. But either way, headed for probate. Now, I said there was only three possibilities, and the third was a trust-based plan. A trust-based plan goes through private trust administration. Trust administration is completely different than probate, and the trust administration never has to see the inside of a courthouse. The big difference is the will distributes property after death pursuant to our probate code. Okay, and the probate code is a court invasive, monitored adversary process, meaning, everybody's got anything you do, the court has to approve. You got to give everybody notice and due process, everything that be done, all your adverse parties, everybody's got, and it just takes a long time. A trust is called 100% probate avoidance. Okay, trust administration never sees the inside of a courthouse because it's done privately. So, a trust goes through our trust code. It does the same thing. It distributes property after death, but it doesn't do the probate code. It goes through the trust code, which is a non-court invasive process, non-adversarial. So completely probate avoidance. So, all right, you've heard me talk about probate several times, and I said I was going to talk about a last will and testament, but I can't talk about a last will and testament without talking about probate, as you have heard me say. So let me go through some things about probate, because, I like to tell people what the pros and cons of probate are, but I can't come up with any pros. I can only come up with disadvantages of it. So let me go over some of those. I mean, if your person has had an experience with probate, you might, in any capacity, maybe you were doing it, or maybe a friend was doing it, or another family member was doing it. I mean, I'm willing to bet and go out on a limb here. I'm willing to bet that it was not a pleasant experience. I mean, it never is. I've never known anybody say, wow, I went through probate and it was a lot of fun. I've never heard of anybody talk about that. So anyway, like I said, what is probate? Well, if you Google the word, it's the proving or the establishing of a will. I once was asked to come up with my own definition of probate, and here's what I came up with. A lawsuit you file against yourself with your own money for the benefit of your creditors. Now, does that sound like something you want to avoid? I would think so. I certainly think it's worth avoiding. So, all right, we're going to talk about this probate process. We're going to talk about the disadvantages of it. There's four big ones. So let me talk about the disadvantages. And I told a trust is 100% probate avoidance. So here's some reasons why you might want to avoid probate. Usually when I give my seminars, I do a PowerPoint and I put this slide up on there. The illustration I put up is it's a slide of a piece, it's like a pipe and fittings, and a real, they go sideways, they go up, they go down, they go left, right, they turn around with twists and turns, go back on itself, has valves, all that kind of stuff. Basically, it just demonstrates like a real tortuous kind of path with pipe. So anyway, at the beginning of the pipeline, in the upper left corner of the slide, that represents the, beginning of the process or the opening of a probate case. So you can try to imagine this. I can't show it to you on radio, but you get the idea. The lower right represents the end of the pipeline, which is the closure of the estate sometime later. So this is, like I said before, this is where I usually talk about the advantages of probate, but in all honesty, I can't come up with any. So I'm going to talk about, the fact that it's so cumbersome. I mean, it's a procedure that's riddled with deadlines, duties, and obligations. I mean, it just invites conflict. So I just have little good to say about it, but I'm going to share that with you. So I'm just going to discuss the main four big disadvantages I think there are to probate for time's sake. There's others, but the big four I'm going to go over. One of the problems with the probate process is it takes a lot of time. The time process in Tennessee, the average time to conduct a probate case from start to finish is 12 to 16 months. That's, I mean, I've done a lot of probate cases for people who never get around to making a trust plan, and the shortest one I've ever done took about 10 months. Now, typically it's a year or more. And Tennessee is what I call a probate-friendly state. My folks passed away in Pennsylvania. My sister was ahead of it, but it took 2 years and 4 months. I mean, just outrageous. So it takes a long time, and that's by procedure. And those are the statistics that the state of Tennessee provides: 12 to 16 months. So, and here's an example why there's reasons why it takes a long time. And here's why. It's not like you're working on it all the time. When you open up a probate case, the first thing that's done is that you set out this 4-month period to allow creditors to file a claim. You know, and I'm sure everybody's seen in the newspaper the notice to creditors, in their local paper, right? Anyone who feels they have a claim or anyone who feels that the deceased owed the money has a 4-month statutory period to file a claim. So basically, in that 4 months, you really don't want to do anything with the claims as they come in because you don't want to pay claim one that comes in and then pay claim two. You might run out of money. And claim the claim that's filed on day 120 is just as valid as the one filed on day one. So we want to wait till they all come in. So it's 4 months where we just kind of, we do other things in that 4 month, but we really can't advance with the creditors. And then once they all come in, then there's another couple months where you evaluate the claims because sometimes you don't want to pay some of them; they're not valid, and so you decide which ones you're going to pay or not. And then if you don't pay somebody, they have a right to be heard. So you schedule a hearing. So if you decide somebody's got a bogus claim or not, it's not valid. They can come in and be heard. So you set a hearing, and they come and say why they should be paid, and you argue, or I argue, why the estate should not. Anyway, once all they've been dealt with, then you move into the inventory phase and the executor's final report phase. And finally, you get to the end of the pipeline. You finally reach what we call the distribution phase, where the assets get distributed to the beneficiaries. That happens about 12 to 16 months after it starts. So let me ask you this. If you left your wealth to people who could use it, or people who need it, like maybe minor children or something like that, or special needs people, you could have to, if they need it to live off of or survive off of, wouldn't it be better for them to get it in a timely manner, if something happened to you, rather than like a year later? Good grief. Anyway, those funds should be available now instead of a year from now. But anyway, okay. It takes a long time. Now, it takes an even longer time if anybody complains about what they want. If you got some kids or heirs that you leave to, and they're not happy with their percentage, and they want to contest it, then it goes uphill from there as far as time. So, I got involved in a contested will case about 10 years ago, and it lasted 5 years from start to finish. It is just ridiculous. So, anyway, okay. Another big disadvantage of probate is the cost. Again, I look at statistics provided to me by the state of Tennessee, and they claim that in the statistical cost of probate in Tennessee is anywhere from 5 to 10% of the estate. That's a pretty big range, 5 to 10%, which tells me that they're just kind of all over the board. Just kind of depends on what's going on. But I don't see them quite that high. I see them anywhere from the 6 to maybe 8% around where in my neck of the woods. Maybe in the big cities, a little more. But anyway, all along this contorted pipeline that I put on the slide are fees that get involved. There's all kind of fees associated with probate. You got your court filing fees. You got attorney's fees. There typically always will be an estate attorney. You can have executor fees. Some courts make executors post bond. If there's any real estate, the probate court will have that property appraised. They won't take your word for it, what it's worth. They'll get a professional appraiser to appraise it. If you got any creditors, that want to throw their hat in the ring, and then, like I said, if anybody launches a challenge, the fees are going to skyrocket from there. Anyway, that's how the probate cost gets to 5 to 10% of the estate. So, I've actually seen some of the attorney's fees alone hit the $20,000 and $30,000 range, which, and those fees are provided, and they're statutory provided by law. I mean, that's by, like I said, by law, those fees are there. Anyway, all right. When I talk about the cost of probate, I want to be clear about something. The probate cost is not something that's a cost to you out of your pocket because you're not here to pay it. But it could be, it is an indirect cost to you because it's a cost that comes out of your estate and it's money that does not go to your heirs, okay, or whoever you're leaving it to. So, I mean, you don't have to write a check for the probate fees because, like I said, you're not here, but all those estate expenses come out of the estate, and that's less and less that you have for the kids or whoever you're leaving it to, right? All right, another big disadvantage of probate that I think is it's totally public. Now, some people say to me, that doesn't bother me too much. I mean, it bothers me a lot. I think the reason it bothers me is I used to do a lot of criminal defense work before I changed into estate planning. And, I mean, I think it bothers me because, those are some of the most creative people I've ever come across. So if you don't think there's people that look at that kind of stuff, I'm here to tell you that they are. When you open up a probate estate, one of the first things we do is publish the will in the probate court for anyone to see. So, I mean, if you want to look at the probate estate, you can walk in the Chancery Court office and say, hey, I want to see the estate of Stan Pierchoski. Well, they have to show it to you. And you can look at it, and there's my will, and you can read it. You can see what I'm giving, all my stuff, who gets it, where it's going to, that sort of thing. I mean, you won't be able to sign it out like I can, but the file, but there's a copy machine right there, and you can copy it all day long if you want. Anyway, the thing is, it's completely public. You can see it. So, what I used to do in my seminars, I always tell people, if you don't believe me, then I put up a slide of Jackie Onassis Kennedy. I put up her last will and testament. And I got all the greats. I got John Lennon. I got the Jerry Garcia, a couple of them. But anyway, the point is, it's public. If you go through probate, it's out there for all to see. And it's public by procedure. I mean, it's not like the court just decided to make this public. I mean, that's what the probate court is. It's all public. And like I said, that bothers me. Some people not so much. But anyway, all right, I want to go over this last thing before the break. The last thing that I think is a disadvantage. As a matter of fact, I think this is the biggest disadvantage. And that is, remember when you get to the end of it, you get to the end of the probate process, you get to the distribution phase where you actually start writing checks to all the kids or all the heirs. You actually distribute the property to them. After everybody's been paid and after all the creditors have been paid, you distribute what's left, called the residual. And anyway, when you distribute that, it's what I call an outright distribution, meaning there can be no strings attached, no terms, no conditions. They just get it, whammo. So let's think about it this way. Leave it to your kids, leave them $50,000. They write them a check and they hand it to them, whammo, it's theirs. Now, what that means is once you distribute to them in the probate process, ownership is complete. So now you can't say in your will what they're supposed to do with it. I get that request all the time. Somebody says, I'm going to put this $50,000, I'm going to leave to my son, but I want him to use it for a college education. And I'll say, well, I'll put that in there, but it's a waste of paper and a waste of ink because it is an unenforceable promise. Okay. People give me all kinds of things I got to put in. I say, I'll put it in there, but it can't enforce it. Once it goes to them, ownership is complete. They may go to college out of respect for you, but they don't have to. And if they don't, then your wish never gets done. So if your wish is important to you, let's not go the will process because you can't guarantee that will be done. Other things are, if you have a child that's got a drug or alcohol problem, you don't want to disinherit them, but you don't want to leave him $50,000, $100,000 that he's just going to go use for the addiction, right? I mean, that would be catastrophic. So anyway, you can't put terms or conditions on it. You can't tie strings to it. They are unenforceable promises. So I'd gone over the 4 big disadvantages of probate. And the last one I was talking about was when you get to the end of the probate process and you just, do the distribution to everybody, it's an outright distribution. No strings attached, no terms or conditions. Well, you might say, well, gee, Stan, why would I want to add any strings attached, or why would I want to put terms and conditions on how my kids get their inheritance? Well, let's think about that. What if your children are minors? Okay, in Tennessee, minor can't inherit. Well, let me put it this way. They can inherit. They just can't get it till they're 18 years old or they're an adult. It's called our Uniform Gift to Minors Act. So in probate, if you have a minor, the inheritance has to be placed in the control of a financial guardian. And that is typically usually another attorney who gets to file his complete hourly rate. And so a court-appointed financial guardian is going to be at great expense to that heir with an outright distribution, because if they're in that position for a couple of years, I'm telling you, I've seen people really pad the bill, and it's really kind of disappointing to me that the industry does that, but they do. What if you have here's another thing. What if you have a special needs child? Special needs children, they usually qualify for government benefits in one way or another. And if they own too much property, they're disqualified. So, if you got a special needs child and he receives an outright distribution from an inheritance, that could have a disastrous effect. I mean, that would, immediately make him disqualified for the benefits. And, that would be, you can't recover from that. Once you're disqualified, I mean, those rules are ruthless. Those policies are ruthless. It's very difficult to recover from that. So, you don't want Aunt Gertrude leaving, you got a special needs child, you got Aunt Gertrude leaves him $5,000 in her will. And then all of a sudden he inherits $5,000. Nothing the special needs child did on his own. It just happened because Aunt Gertrude didn't know any better. And you end up with a terrible, terrible situation. So, in that case, we make a special needs trust. That way you can leave as much money as you want for the benefit of that person, but it never belongs to them, so they can't be disqualified. We'll get into that in a future show, special needs trust. I mean, what if you got a kid that's a spendthrift? I mean, what if you got a kid that blows through money like water? Okay. Anybody got one of those? Yeah, I'm not going to say, because maybe my kids are listening. I don't know. But anyway, I mean, anybody want an 18-year-old to get a large sum of inheritance? Not me. I don't want it to be all, hey, jacked up truck, big party, blow. I want it to be used on something like a good start, college education, down payment on a new home, start your own business, or some of those things that can really cripple young adults and stuff. So, if you got somebody just blows through it, you can leave it to them so they can't blow it all at one time. You leave them some at age 25, some a third at 30, and another third at 35, stuff like that. There's all kind of schemes that we can do to distribute it so they don't blow it. And I already mentioned, if you have a child with a drug or alcohol problem, you don't want to disinherit them, but you don't want to make the addiction worse. So there's a way to leave it to them so that they can't be used for the drug or alcohol problem. And here's a big one that a lot of people talk about. I call it divorce proofing. And if you Google that term, you won't get it because it's my term, but you can divorce proof it. Now, what's that mean? If you have a child that's married, adult child that's married, and if they get a divorce, I mean, or at least I don't, you don't want the divorcing spouse leaving with half your child's inheritance, do you? I can't imagine anybody that would want that. So let me give you an example. I got 3 kids. Only one of them was married, my daughter. She'd been married, just celebrated her 5th anniversary not too long ago. So the marriage is going fine. I mean, it's not like I see a divorce on the horizon. I mean, my son-in-law is a great guy. I love him to death. But here's the thing. What about 20 years from now, right? I mean, the theory is everybody's in love when they get married, right? I mean, that's just the way it works. Nobody pretty much sees the divorce coming. So, if she gets a divorce, I mean, she's my daughter. If she gets a divorce, I don't really care who's at fault, but she's now going to be involved in an adversary process in court, and her adversary is going to be her divorcing spouse. And I do not want him walking away with half of her inheritance. So I can divorce, I want to divorce proof her inheritance so that doesn't happen. And a lot of people feel this way. Now, you don't have to have a child that's married and you already think they're going to get divorced, okay? Like me, I don't think they're going to get one. I hope they never do. But if they do, I want to make sure her inheritance is protected. You don't need to see it coming to be prepared for this. I actually had a client one day sitting in my big conference table, her and her husband, and they had a son, an only son. They had a nice little business here in town. And, she said, I want to leave everything to my son, but she said, and she points her finger at me and she says, but I don't want that gold digging, of a wife to get a dime. So, I mean, she made it perfect here. And I said, we can do that. We can divorce proof it. That way, if that's important to you, we can do that. Now, those are terms and conditions. Okay. You can't do that with probate. If you leave it to your spouse, if I leave it to my daughter, it's hers. If she commingles those funds with the joint bank account and they use it to pay the mortgage, pay the light bill, pay for the kids' school, I mean, she would have converted that separate property, which inheritance is, to marital property simply by how she used it. When you get into divorce court, the divorce court only has jurisdiction over dividing marital property, not separate. So Anyway, that may be a topic for another show, but um, we can divorce proof it. That's a big one. A lot of people like to do that. What if your kids have any creditors or lawsuits going on? Suppose you got a child entrepreneur type, he gets into business, he's doing something, gets sued, or in a high risk profession, I'm in a high risk profession. I can get sued for, I give you bad advice and you get damaged by it. That's actionable. So, anything in the health profession, some real estate, stuff like that. If they get sued, I would like my inheritance not to be used to satisfy their creditors or a lawsuit. I mean, it doesn't make their lawsuit or their creditors go away, but it makes it so they can't use the inheritance I leave them to satisfy that. I want it to go to something else. So, I mean, that's a good thing. You can credit or proof it from them all day long. You can leave it to them and you can protect it from their creditors. And some people come to me and they say, well, what about other probate avoidance techniques? Like, what about joint ownership of property? Now, joint ownership is something that we do. So let me put it this way. If you're a husband and wife and you own property in the state of Tennessee, by default, whether the deed says it or not, but by default, you will own it as right of survivorship. Tenants by the incommoner, tenants by the entirety with right of survivorship. And what that means is at the death of the first spouse, all ownership instantly vests with the survivor. That is a probate avoidance tool, and we use that, okay? That's one of the reasons why you rarely ever have to probate the first death, because the property usually transfers by survivorship, not by probate. So, we use that whenever we can, because that, like I said, that is a probate avoidance tool. But unfortunately, at the second death, the survivorship is, most assuredly is going to end up in probate because, the survivor is passing away, and usually they have a will that says it goes to my children after the second of us, husband and wife, to pass away, right? Okay. How about beneficiary-driven items like life insurance? Those pass outside of probate. You have a life insurance policy and you name, well, let's not say your spouse, let's say your child. You name your child as the beneficiary. Well, if it's a qualified death, your kid will have to file an application or make a claim, and they'll cut them a check, $100,000 life insurance policy. They'll cut them a check for $100,000. They're not going to call the probate court and say, hey, did Stan Pierchoski open a probate estate? Is it okay if I distribute that money to his kid? I mean, they don't care. I mean, they have an obligation by contract, not by probate, not by survivorship, not by trust, but by contract. They're just going to pay anyway. It's like an outright distribution. You can't control how they pay it, but they're just going to pay it. I've had people call the insurance company and say, hey, listen, my kid's a spendthrift. He'll blow through that money. So don't just give it to him all at once if something happens to me. You know what they say? They're going to say, look, lady, or look, buddy, we have an obligation to pay on your death, and that's what we're going to do. If you got a problem with your kid, that can't be our problem. We're just going to cut a check. That's what the contract says to do. So now, beneficiary-driven instruments are probate avoidance, and we use them where we can but there's not that many things that are beneficiary-driven like that. So, and we use them wherever we can. So, if what you heard this week has piqued your interest, I'm glad. My mission is to get the message out that when it comes to estate planning, you have options, lots of options. If you have any questions about your own circumstances, I'm more than happy to take the time to answer. You can call my office at 931-363-7222 or send me an email at stan@pierchoskiestate.com. That's Stan, STAN, at PIERCHOSKI, estatelaw.com. Visit my website and check out where I'll be giving my next free educational seminar. My website is www.pierchoskiestate.com. Thank you for listening to Bulletproof Estate Planning, and I am Estate Plan Stan.